Well, today actually happens to be the anniversary of one of the greatest novels from the 20th century. On the 8th of June 1949, George Orwell finally published 1984, a book that has completely transformed our thinking about data security. Unfortunately, it took George Orwell so long to finish the book, and it took an awful lot of toll out of him, out of an already frail man, that he died only 6 months after he published 1984 at the age of 46. But had he lived, he would have seen how much he was bang on correct about how society became this big brother society that we do live in today. Except for he mistook one thing, and he miscalculated for one thing. He never anticipated that we would actually voluntarily serve up to Big Brother all our personal thoughts via Twitter, all our photos on Facebook, our CVs on LinkedIn, and pretty much every personal data that we have, we actually, in most cases, serve it up voluntarily. And actually, I think today's bigger concern amongst the generation we have is that Big Brother is not watching, and we actually get annoyed when Big Brother's not watching instead of that being our concern. So here today we have two speakers who are experts in this field, and gives me great pleasure to welcome Gayle Gorvett and Alfred Farah. Gayle is the founder and managing director of GGorvett Consulting in Paris, where she works as an external legal advisor to multinational companies and entrepreneurs, advising management on negotiation of complex contracts, the implementation and audit of compliance programs, and negotiation of strategic partnerships, and negotiation with potential investors. Gayle is an international corporate lawyer and advisor with over 16 years' experience advising clients in the US, EMEA, and Asia Pacific. She has lived and worked in the United States, Japan, and France, and has a law degree from Northwestern University School of Law and a BA degree in international business from DePauw University. Alfred is the general counsel at International Baccalaureate in Switzerland. He is a tri-national Swiss and US qualified lawyer with broad experience in legal and compliance matters in diverse legal systems, cultures, and industries, as well as in the not-for-profit sector. In his current role as general counsel of Swiss Education Foundation with global operation, he heads a legal team with a strong focus on privacy, as well as other regulatory compliance, intellectual property, and IT contracts. Mr. Farah's former roles include Chief Legal Officer at a Fortune 500 automotive safety innovator. He was compliance counsel at a FTSE 100 global anti-bribery program rollout, and European General Counsel of a contract manufacturer with over 200,000 employees. So please welcome our two speakers, and first I'd like to invite Gayle to speak.
I'd like to thank you all for staying through what was sort of a long session this morning and still being here and awake this afternoon for this session. And thank you, Hugh, for that introduction. It's fitting that you talked about Big Brother because the topic of my discussion today fits in well with that introduction, which is data privacy versus national security in the post-safe harbor landscape. This has been sort of a hot topic of late in the EU and across the border in the United States, where I'm from. If you can tell, I have an American accent. Although I live and work in Paris, I'm not French. These two issues are actually quite juxtaposed at the moment, given what's been going on with a lot of the American technology companies. So I'd like to talk to you about just a general overview of what brought Safe Harbor into existence, then the introduction of the Privacy Shield, which we all thought would be in place by now, post-Safe Harbor alternatives for those companies that actually still need to be able to transfer data from Europe to the United States, as we're now in a situation of flux For those of you who follow these issues, you know that the EU has decided to not recommend the adoption of the Privacy Shield very recently, and the current state of affairs with the Privacy Shield, the national security debate, which is going on both in the European Union and the United States, which raises another level of concerns regarding privacy and access to data on another level. As most of you probably know, the Safe Harbor agreement came into existence because privacy and the right to privacy for your data is considered a fundamental right in the European Union. And a number of key concepts in terms of data controllers were brought into existence under the current data privacy directive in the European Union. And it was considered that if you wanted to transfer data, and especially if data controllers wanted to transfer data outside the key European Union countries, they had to transfer data to a country that was considered to provide an adequate level of data privacy. Certain countries were put on a list as considering to provide adequate levels of data privacy. Switzerland was one of them, but the United States was not considered to provide that level of adequate protection for data privacy. So because there was so much international commerce at issue, and everyone realized that there had to be a solution found for the transfer of data between the United States and the European Union, the Safe Harbor privacy principles came into play in 2000, which allowed companies to sign up to these principles and to self-certify, indicating that they would be providing the same level of protection as was provided under the Data Privacy Directive in the European Union if data was transferred from the EU to the United States. And companies that signed up to Safe Harbor self-certified, and then they were monitored in the United States by the Department of Commerce. The Safe Harbor privacy principles were considered to provide an adequate level of protection by both the European Union and the United States for 15 years, and allowed for companies, over 4,000 companies, to transfer data from the European Union to the United States under those principles until a lawsuit was brought by Max Schrems against Facebook. Of course, one of the big U.S. technology companies, which is often talked about in the media these days with respect to data and the treatment of data, in relation to the NSA PRISM program, which was going on at the time, collecting bulk data in the United States. And he alleged that the United States failed to provide sufficient safety for EU personal data, and that the self-certification also was not sufficient in terms of providing adequate protection under Safe Harbor. So, as I'm sure most of you know, Safe Harbor was invalidated by the European Union Court of Justice earlier this year, and ever since then, the European Union and the United States have been trying to find an alternative to allow for the transfer of data between the European Union and the United States, which is where we came up with the concept of the Privacy Shield, which many people refer to as Safe Harbor 2, which has been negotiated between the Department of Commerce and the Article 29 Working Party to provide for a new global framework and allow for safe data transfers between the United States and the European Union. Now, the Privacy Shield has been negotiated for quite some time and pretty intensively between the European Union and the Department of Commerce. And it provides a much more robust framework and many additional protections that were not provided for in the safe harbor. Within the European Union, there was a fair amount of support for adopting the Privacy Shield within the legal community, within the privacy community, and even within the European Union for quite some time. There was even you can see there are several principles in the Privacy Shield, including the creation of an ombudsman by the Department of State that allow the EU citizens to submit inquiries for complaints regarding a collection of data, the entire regime being subject to yearly review, the fact that EU citizens have the right of redress, and a free ADR system that makes it a fairly robust system. U.S. law enforcement access to personal data is subject to clear conditions, limitations, and oversight, and has been substantially curtailed since Safe Harbor actually was struck down by legislation in the United States. However, in spite of all that, very recently, the Article 29 Working Party has recommended that the Privacy Shield not be adopted in its current form. On May 26th of 2016, the European Parliament recommended that the EU continue negotiating with the United States to improve the data privacy shield, citing the U.S. surveillance authorities' access to EU data of individuals transferred under the privacy shield. The fact of the matter is that U.S. authorities no longer have the right to collect bulk data. There's been legislation to this effect since 2015, so this seems like a strange reason to recommend not approving the Privacy Shield. They also cited the fact that the Ombudsman is not sufficiently independent nor vested with adequate powers to exercise or enforce its duty. However, this was also very strongly negotiated between the Department of Commerce and the Article 29 Working Party as part of the Privacy Shield. So that also seems slightly perplexing. They finally cited the complexity of binding arbitration mechanism that should be more user-friendly and effective as a reason that they are recommending that Privacy Shield be rejected. I'm not so sure how much more complex the arbitration mechanism in the Privacy Shield itself is than other methods of arbitration that we all know of and have used ourselves. But I'm sure this is something that could be fairly easily worked out. So the current state of affairs that we're left with is we have no actual concrete alternative to safe harbor between the United States and the EU in effect. We have EDPS Buttarali stating that significant improvements are needed to respect the essence of key data protection principles in order for Privacy Shield to be adopted by the European Union. However, within the Europe itself, we see governments like the French government increasingly adopting strong surveillance legislation, which goes far beyond what the PRISM powers of the United States surveillance ever were. So it's somewhat perplexing that they talk about protection and essence of data protection principles with respect to adoption of the Privacy Shield, when in Europe we're seeing the surveillance powers of governments like France and Britain, in fact, go the other way. Also, at the same time, governments are increasingly seeking backdoor access to encrypted data in the name of national security. We've seen this quite frequently lately, where European Union governments, and also this has happened in the United States, have asked companies like Facebook, Google, Yahoo, and Amazon to give them backdoor access to encrypted technology since the Brussels attacks, since the Paris attacks, in the name of national security. And we have to query whether this is really consistent with a fundamental right to privacy. In Britain right now, legislation, the Investigatory Powers Act, is being contemplated that would force technology companies to bypass encryption technology in the name of national security, which could compel companies to aid law enforcement by hacking individual smartphones, computers, and possibly hold records of websites visited of people for up to 12 months, for example. In France, in addition to the increasing surveillance powers that have already been given to national security agencies since the terrorist attacks, they're debating another expansion which would provide for criminal sanctions to tech companies up to 5 years in prison and fines of up to $390,000 if they refuse to provide encrypted technology access to investigators. All of this at the same time that we're saying, the proposed privacy shield is being rejected because we're concerned about the bulk collection of data. It seems somewhat contradictory. There is some light at the end of the tunnel in that certain countries within the EU, such as Germany and the Dutch authorities, seem very opposed to this tendency to seek backdoor encryption as the favored way of pursuing national security interests. They think that it seems like a dangerous trend and that seeking access to data in that manner could also open the door to criminals having access, to other terrorists having access to that data, and that it's a dangerous trend. EU cybersecurity experts also believe that that's counter to a fundamental right to privacy and that we should not pursue such legislation within the EU. So where do we go from here? We don't really know what's going to happen with the Privacy Shield since its adoption has not been recommended by the Article 29 Working Party. Safe harbor has been invalidated, and yet multinational companies still have to continue to do business. The new GDPR legislation, which has recently been adopted, it has a broader territorial scope than the previous privacy directive. So multinational companies are already facing broader privacy demands. And we need to figure out what the options are for EU-US data transfer post-safe harbor. For companies that need to find a solution and need to continue to do business and transfer data from Europe to the United States post-safe harbor, there are some alternatives. They're becoming increasingly narrow, you'll see. Several alternatives have been recommended by the European Commission. One of the things to keep in mind is that in its decision invalidating safe harbor, the European Commission gave increasing authority to the individual data protection authorities in all the individual member states. So in the interim, where there's this judicial void, each member state data protection authority has jurisdiction over the data transfers from its country outside the territory, which leaves us in a very difficult situation because, as you'll see, the German data protection authorities have come out strongly against the use of the model clauses, which is one of the alternative ways to transfer data from from the European Union to the United States that has been recommended by the European Commission. The German authorities have said that even though it's recommended by the European Commission as a favored way of transferring data, they don't necessarily approve that alternative. You still may be able to use that within Germany, but you have to use the exact model clauses with no amendments in order to be certain that you have the ability to transfer data under the model clauses if you're doing it from Germany without having a potential issue. The other thing to note with respect to the model clauses is that very recently the Irish Data Protection Authority has decided that it's referring a case complaining about Facebook's use of the model clauses to transfer data from Europe to the United States. So there's a cloud hanging over the use of the model clauses as a whole, as a mechanism for transferring data from Europe to the United States. This decision probably will not be decided for at least 18 months. So we're in sort of a state of flux as to where that stands. For the moment, the current state of affairs is that this mechanism has been recommended officially by the European Commission as a preferred method for being able to transfer data from EU to the United States as long as you use the standard model clauses. But since this decision is in the courts, it still leaves sort of a question mark as to their ultimate validity. One of the other options is to adopt binding corporate rules. That's only for intercompany transfers. So if you're transferring information from one affiliate to another within a multinational company, that's an option. Of course, this is for larger companies, which is good because it tends to be an expensive mechanism. It's also fully supported by the Commission, but it requires prior authorization in most EU states. It is an expensive mechanism because you have to get the model clauses approved in one data protection authority, then that data protection authority submits them to the other data protection authorities for their approval. Sometimes there can be objections by the other data protection authorities, so this can be a long, drawn-out process. There is still the possibility for a derogation from safe harbor. This is to be used with caution and is not for long-term transfers. It's only if you have unambiguous consent of the subject and it's given freely, and if the transfers are necessary for the performance of a contract between the data subject and the controller, things like booking a hotel room, reserving a flight. The other alternative is to be fully compliant prior to 2018 with the GDPR directives. Obviously, this shows good faith, the intent to provide the adequate and necessary level of protection to the data that is transferred and the added benefit of being in compliance with EU data protection law. The difficulty is there are more requirements in the GDPR than there were in the data protection directive. It can be more onerous, more expensive, and can also require the appointment of a data protection officer. So this is something you need to take into consideration both from a cost-benefit perspective before taking that approach. There are expanded definitions, obligations, the introduction of the right to erasure and the right to forget, the updated privacy notices, consents, and policies, the new reporting requirements, and the restrictions on profiling. These are just some of the biggest examples of the additional obligations that have been put in place by the GDPR that were not in existence before. to you.
Thank you, Gayle. Thanks. A question I have is, Safe Harbor is invalid. The privacy shield looks like it's dead in the water. As you say, model clauses are under threat. So is it enough if a US company just becomes fully GDPR ready and makes that their objective with all the additional criteria and things that they have to do to get to that stage? Will that ensure that they are then able to transfer data from the EU to the US and without any further problems? Or are these two separate issues?
Well, I hate to put anything in absolute terms because the way things have been going in this area, anything could happen. Who would have thought that the German Data Privacy Authority would be making the kinds of claims that they are against companies? For example, the other day they pursued 3 American companies for not adopting an alternative to Safe Harbor fast enough. And I don't have information on what fast enough is at this time. And the fact that the model clauses are being looked at as an invalid solution, I think I wasn't expecting that either. I would say, to me, full compliance with GDPR seems like a pretty safe bet. If being fully compliant with what seems to be a fairly onerous data protection regulation and what is applicable to all European companies is not enough, then I don't know what would be.
Great. And does the US government need to do anything more to satisfy the European Union? Or what else can the US government do to satisfy the European Union?
That's difficult. They've already, the Privacy Shield framework that's proposed itself already involves the direct involvement of the Federal Trade Commission, the Department of Transportation, and the oversight of the Department of Commerce. It involves the pursuit of any violations under U.S. law. Companies that sign up to the Privacy Shield are not only self-certifying, but they're agreeing to be pursued under U.S. law, as well as subject to ADR and European Union regulations. So at this point, I'm not sure. They've also added the concept of an ombudsman, so that European citizens can directly make claims. It seems to me like there's been a lot of good faith and a lot of additional provisions put in already. I'm not sure what else can be done at this point.
Right. So the GDPR is sort of the light at the end of the tunnel. In 2 years' time is really the end point.
It seems like it. Yeah.
Great. Any questions? Yep. Do we have a microphone? Or?
Yeah, my question is this: how do you balance national interest, national security interest of the state, and the right to privacy of citizens?
You mean with respect to the encryption issue, or are you just generally data privacy issue, or?
The invasion of data privacy. How do you balance the national security interest with the right to personal privacy of citizens?
So are you talking about the issue of the governments that are asking for the backdoor access to? Well, I mean, in Europe, we've said that data privacy is a fundamental right, and it's become a very, very big topic in the past 3 to 5 years, especially with the negotiation of the new GDPR legislation, and which is going beyond just this bill, because now we've got other initiatives that are still in the works that are going to be coming out by the end of 2016 on cloud issues and other things like that. And so to me, it's either a fundamental right or it's not. And once you have agreed on the principle that it's a fundamental right, it seems somewhat hypocritical to then say, oh, but we've decided to ignore that right in this one particular case in the interest of national security. And we can protect against criminals and terrorists and other countries gaining access to the data that we want access to through the back door that we are asking you to create in some fashion that we have yet to disclose. I mean, because this is what's being argued, is that we want a back door for the interest of national security, but somehow we're only going to get that access for national security, and we're not going to release the information that we've said needs to be protected on a fundamental basis to all these bad actors. I don't have that level of faith in any government. And so I guess my concern is if really we need to protect our own data and the data of others and the data of our children on a fundamental basis, we should be protecting it from everyone.
I think this is a discussion we could have forever. It's fascinating. It opens up so many different areas on human rights and everything. I'd like to now ask Alfred Farher to come up and speak about data protection in education. Thank you.